Good afternoon. My name's Colin O'Brien. This is a free Florida bar approved CLE. It's on Zoom. It's called Significant Florida DCA Cases Handed Down in January and February 2024. It's a 1 credit hour CLE. It's Florida bar approved, and this is the reference number on this page. If you haven't received the PowerPoint, which I'm going over in the chat, send me a note and I will get it to you. Cullen@CullenO'BrienLaw.com. In any event, the reference number is 2400759N. This is an intermediate level CLE, and the title is Significant Florida DCA Cases Handed Down in January and February 2024. Can you guys hear me? Can someone just speak up and let me know that they can hear them? I can be heard.
You're good to go, Cullen.
Thank you, Dan. So this CLE is on Zoom and it's being recorded live and it will be rebroadcasted. I have a YouTube channel where I upload my CLEs. It's being conducted by the Florida DCA Wizard LLC, which is my company, and I provide real-time case law updates. So this CLE will cover significant opinions in all 6 district courts of appeal since January 1st, 2024. So January and February. I didn't get to the ones today, but I review every single opinion that comes out, and there have been over 250 written opinions in all 6 DCAs handed down since January 1st, 2024, and this CLE will cover about 20. Just as a refresher, if you guys haven't looked at a DCA map in a while, can everybody see the DCA map?
Yep.
Okay, so the first DCA is up here in the Panhandle. The 5th is the pink one in the northeast part. The green is the 2nd. The middle part, that's the new 6th DCA. The 4th is over here with Broward and Palm Beach, and the 3rd is down at the bottom. Since January 1st, 2024, there were 33 written opinions in the first DCA. There were 40 out of the 2nd DCA. There were 55 out of the 3rd DCA. There were 76 out of the 4th DCA. There were 40 out of the 5th DCA, same as the 2nd, and there were 12 out of the 6th DCA. Now, when I say written opinions, I mean opinions that are not PCAs, that are not just like affirmed and then case law cited, but like actual opinions. So I review all the opinions. I actually have an app that I summarize them, and they're contained in the app, which I'll talk about at the end of the CLE. And I picked out 20. I grouped the 20 into these 6 areas. If you have a copy of the PowerPoint, there are hyperlinks to the cases so you can follow through and click on the cases. These are some themes that I tried to group out of 20 cases that I thought were interesting. Obviously, everyone's going to have their own opinion of what a case means. Cases are very long. I'm trying to be terse here and trying to cover some ground. But these are the subject areas I group them into. You can read the cases yourselves and come up with your own ideas, but this is something I thought would be interesting to present in this fashion. So why don't we get started? So there are 3 sanctions cases. The first one we're going to talk about is Clemens versus Club Space out of Miami-Dade County. Judge Miller is the judge, and this is about what happens when you fail to abide by a trial order. The next case is Goga versus Publix out of Broward County, Judge McCarthy. This is about what happens when you lie about a medical condition. And the next one is Malik versus Malik, Miami-Dade County, Judge Demetrius. And this is about shooting the other party's pets during litigation. A couple people just joined, so I'm going to stop the share and put the PowerPoint into the chat real quick so everybody can have a copy of this copy of this PowerPoint. One moment, please. Okay, PowerPoint is in. I have to keep uploading the PowerPoint every time someone joins. All right, so these are the three cases, and let's talk about them. So Clements versus Club Space, Miami-Dade County, Judge Miller. Again, if you have the copy of the PowerPoint, there's a hyperlink anytime you see the case, and you can click on it. You can read it yourself now or after the CLE. So the plaintiff tripped over a railing at Club Space, which is if you guys have never been to Miami, it's a place you party past midnight, and fell down and sued for injuries. Before the trial order came out, the plaintiff's attorney withdrew, which meant the plaintiff was proceeding pro se. A trial order, as you all know, are orders that make a definitive date for a trial, calendar call, dates for exhibit list, witness list, jury instructions, mediation, all that sort of stuff is in a trial order. Before the trial order came out, the plaintiff was pro se. And so the plaintiff was proceeding pro se and trying to represent herself. A month before trial, the plaintiff had provided no discovery responses, no witness lists, no exhibit lists. So no discovery responses, no witness list, no exhibit list. The Judge Miller struck the plaintiff's pleadings for that. It was a month before trial. It wasn't like right at trial. And the Judge Miller just dismissed the case. The third DCA said that Judge Miller was justified in striking the pleadings. The language here is Ms. Clemens offered conclusory allegations, but no support in the record for the contention that the trial court abused its discretion in striking the pleadings on the eve of trial in the face of a complete lack of any attempt at compliance with multiple orders after multiple hearings and admonitions by the trial judge. The trial order, the judge's own words, and the multiple orders providing deadlines put Ms. Clemens on notice as to the possibility of sanctions, and the fact that she represented herself is ultimately no excuse in the face of the multiple failures to comply. The trial court appeared to take Ms. Clemens' status into account, giving clear instruction and multiple opportunities and explaining the importance of compliance and the severe prejudice that Club Space would face. The reason why I think this is interesting is because I can't tell you how many calendar calls I've sat in, either with opposing counsel or just listening to other calendar calls, and meaning like the trial settings the next week or the week after, and people haven't provided their witness list, their exhibit list, their jury instructions, and whatnot. This case seems to be strong medicine that one could use if one was looking to try to get the other side sanctioned for not complying with trial orders. If a pro se gets sanctioned for this, which usually the standard's a little bit easier on a pro se, then lawyers should have to follow this. I thought it was an interesting case. All right, next case, Goga versus Publix, Broward, Judge McCarthy. This was a slip and fall at Publix. The plaintiff said she was injured, and she described her limited physical condition in the discovery responses. She said, cannot lift anything heavy, can't do any physical sport activities, can't walk or stand for long periods, can't go places with both children alone, severe pain post-op, not a mother I was. That's a direct quote. Sounds like Yoda, but that's a direct quote from the opinion. 34 years old, will never be able to do activities I did pre-fall. So she said this is how badly she was injured as a result of the slip and fall. Publix put a private investigator on it and filmed plaintiff's conditions, and this is what the private investigator found. Multiple videos depicted the plaintiff picking up and carrying her children across parking lots, loading and unloading her vehicle with multiple bags of purchases, walking and bending at the waist, all without any hesitancy or movements indicating pain or limitations. So Publix said, the discovery responses said she was injured like this. We filmed her like that. She was lying. Court, please dismiss this case for fraud in the court. And Judge McCarthy dismissed the case for fraud in the court, for lying to the court, lying about her, how badly she was injured in the slip and fall. Well, the fourth DCA reversed that decision. And there's language in this reversal that I'm having trouble getting my head around. It's very interesting and provocative, to say the least. The fourth DCA said that dismissal was too great of a sanction. One of the quotes is, in balancing the policy favoring adjudication on the merits with competing policies to maintain the integrity of the judicial system, trial courts must keep in mind that misconduct that falls short of the rigors of the fraud in the court test, including inconsistency, non-disclosure, poor recollection, dissemblance, and even lying, is insufficient to support a dismissal for fraud, and in many cases may be well managed and best resolved by bringing the issue to the jury's attention. Wow. And then the court said the plaintiff had intentionally lied about the extent of her movement limitations, and pain after medical treatment for her fall in the defendant's store, but distinguished it and said this is not like the numerous cases granting dismissal for fraud in the court where the plaintiff lied during discovery about prior injuries and prior conditions. I have a hard time getting my head around this. I thought that lying gets you dismissed. But in this sort of injury case, I guess maybe the court is saying if you embellish your injuries, it's not so bad as making up that you had a prior condition that was exacerbated. Still tough to get your head around. It's an interesting case. Okay, Malik versus Malik out of Miami-Dade County, Judge Demetrius. The wife obtained a domestic violence injunction against the husband. And then after that injunction was issued, the husband took a pellet gun and shot the wife's cats. And the wife brought it to the judge's attention, and the judge said, okay, husband, this is what you get for shooting cats during the pendency of this injunction. I'm going to give you 50 hours of community service. The third DCA reversed that decision. The fifth DCA said the following: the 50 hours of community service imposed by the trial court constituted an alternative to incarceration. Hence, husband was entitled to the same constitutional protections that are afforded to any criminal defendant in a criminal proceeding. While we are not unsympathetic to the dilemma the trial court faced from husband's conduct, and while we certainly do not condone husband's behavior, once wife withdrew her motion for indirect criminal contempt and pressed a motion for civil contempt only, the trial court could not employ its inherent power to sanction where the sanction was penal in nature. So I guess the message is, if you're only going for civil contempt, there can be no criminal sanction, whether it be community service or incarceration. It could have only been a monetary fine because indirect criminal contempt was off the board. All right, here are some case management cases that came out. Little versus Turnbow. This is about failure to attend a case management conference, and Kirkpatrick Trust versus Lakeview Loan Services out of Duval County. Judge sued, and this is about hearings on issues not in the notice of hearing. Case management conferences are a lot more frequent now that I think trial courts are under a lot of pressure to move cases along. Case management conferences, as you know, are conferences with the judge and the lawyers to talk about the status of the case. It's like a checkup. What else needs to be done in this case to get it to a resolution? Have you mediated? Have you done all your discovery? What are you waiting for? Can we set it for trial? What's left to do? And a lot of judges are now even doing those once a month, a couple times a month, to make sure that cases just don't linger on the docket. So case management conferences now are a lot more frequent than they used to be pre-COVID. But in any event, in this Little versus Turnbow case out of Flagler County, the plaintiff failed to attend a case management conference, just didn't show up. These things get set all the time, and you're kind of on a docket for like 2 hours. Your case management conference is like 8:30, and then it's not till like 10:45 that your case gets called. And I'm sure you've seen it where people aren't there and the judge is like, hey, call the lawyers or whatever. But this time the lawyer wasn't there, and the trial court just dismissed the plaintiff's case. Oh, you didn't attend? Plaintiff's case got dismissed. And the plaintiff moved to lift the dismissal order and said, quote, his failure to attend the case management conference was due to a clerical error on his calendar committed by his assistant. Blame it on the assistant. The assistant mistakenly believed that the case management conference had been canceled. As a result, the case management conference was not on counsel's calendar, and he did not attend the conference. Counsel averred in his motion that, to his knowledge, he had never missed a scheduled hearing during his years of practicing law. Judge, it was my assistant's fault. I've never missed a hearing ever. Please don't dismiss the case. And the trial court just denied the motion to vacate. Said, no, I'm not undoing my dismissal. But the trial court did not make any findings. The fifth DCA reversed and said that a trial court may, among other things, dismiss an action when a party fails to attend the case management conference. However, because dismissal is recognized as, quote unquote, the harshest of all sanctions, a trial court, in dismissing the action, must explicitly find that the party's actions were willful, flagrant, deliberate, or otherwise aggravated. The final order of dismissal in the instant case contained no such findings. So if you find yourself on the right end of this and you're at a case management conference, the other side isn't there, they haven't showed up to a lot of things, and you want something harsh, there needs to be findings inside of that harsh order. That's my takeaway here. But it's also pretty scary that you can have your case dismissed if you missed a case management conference. They're really important, in other words. Okay, the next case about case management conferences is Kirkpatrick Trust versus Lakeview Loan Services out of Duval County, judge sued. Case management conference, and again, this is a status checkup. You could have a 5-year-old case and the judge has, or somebody sends a notice of a case management conference to wonder why the thing hasn't gone to trial or what other discovery needs to be done. And so here at one of those case management conferences on a case, there was a pending motion to intervene. A lot of times you go to a case management conference, there's a pending motion for this, there's a pending motion for that. There could be 20 pending motions. At the case management conference and during the pendency, the defendant filed a notice of a case management conference, and that notice did not indicate that the motion to intervene or any other motion would be heard at the conference. So there was a notice saying we're going to have a case management conference, but it just said case management conference. It didn't say case management conference, and we're going to talk about a bunch of things. Well, at that conference, the trial court said, oh yeah, there's this pending, let me look at what's going on in the docket. Motion to intervene. Yeah, I'm just denying that motion to intervene. Denied. The fifth DCA reversed that and said due process was violated because the notice setting the case management conference didn't indicate that any substantive matters might be heard at the case management conference. Now, a lot of times when you see case management conferences, there's a notice. It's usually the court's own notice. And the courts sometimes, in this case, it was a party did a notice. So like a lawyer drafted a notice and said case management conference. But when you see the court issued notices for case management conferences, usually there's broader language, case management conference, and be ready to talk about other matters. The question I think this case raises is what's on the table at a case management conference? The fifth DCA kind of put its toe into it, but didn't quite definitively answer. Here's what this is in a footnote. Here's what the fifth DCA said. So the trial court's initial case management order stated in pertinent part, at the hearing, the court may facilitate the elimination of legal or factual issues. Come to the case management conference and be ready to facilitate the elimination of legal or factual issues. But because that order setting the initial case management conference is not at issue here, and the notice of case management conference filed by Lakeview did not contain that or similar language, we do not express a view as to whether this language would have constituted sufficient notice that the trust that their pending motion to intervene or any other motion might be heard at the conference. I guess a policy reason for not being ready to argue 10 different motions is case management conferences can be very expensive. If there are cases that have a lot of motions and you're supposed to show up at a 5-minute case management conference, being ready to argue 10 different motions, I don't know. I guess safe money is to be prepared for everything. I don't know that the fifth DCA answered this definitively, and I could see an argument that due process would be violated even if you had broad language like elimination of legal or factual issues if the court adjudicated a pretty substantive motion at a case management conference. Food for thought. All right, here are some civil procedure cases. Wu versus Alum out of Miami-Dade County, Judge Silver. This is a judicial default after avoiding service of process. Yatak versus La Placita, St. Lucie County, Judge Warrenicki. This is about punitive damages and arm's length business disputes. And Bioze versus Orasan out of Broward County, Judge Levinson. It's about personal jurisdiction. Okay, Wu versus Alum, Miami-Dade County, Judge Silver. The defendant was served with process. You start off a lawsuit by taking a summons and giving it physically to someone and saying, this is what you're being sued about. You have 20 days to answer. The person got that piece of paper and didn't do anything. So there was a default, meaning they lost. So after they had lost by default, they moved to lift the default and said that service was improper. And so in the fight over service of process, the plaintiff side said their process server had an affidavit that said he personally served the defendant with 2 summonses at the registered address of defendant's business, which is also the address of the registered agent. In the motion challenging service of process, the defendant said it wasn't him. He claimed that he never had personally been to that address and that the returns of service contained an inaccurate physical description of him as the person served. So the basis for challenging service of process wasn't me. I never even been there. The trial court found that service of process was proper, did not believe the defendant, but vacated the default and said, okay, we'll give you another chance to litigate this case. We won't just make you lose. Both sides appealed. The service of process challenge got appealed, as well as the default side. And the third DCA said that the service of process argument is not good. You can't just say it wasn't me. You have to have some evidence. The quote is, a defendant may not impeach the validity of a summons with a simple denial of service, but must present clear and convincing evidence to corroborate his denial. Can't just say it's not me. You have to have some evidence. Then the third DCA said, you know what? And they should have been defaulted anyway. You don't get to litigate anymore. You can't just sit there, say it wasn't me, and then try to come back and litigate. It's pretty harsh. Here's what the third DCA said. Here, the excusable neglect claim relies solely on defendant's claim of lack of service and nothing more. Defendant would be required to provide similar proof as in the motion to vacate. However, the court found the service valid on its face and was left with a bald, unsupported, and according to the court's own determination, partially discredited or inconclusive claim of non-service. This fails to provide a competent or substantial evidentiary basis to support the court's finding of excusable neglect. So you can't just sit there and not do anything when you're served. All right. Next case, Yatak versus La Placita, St. Lucie County, Judge Warrenicki. This was a dispute over a grocery business. It's a little complicated, but there was a business, and then there was land on which the business sat, and the plaintiff had a right to buy the land, but the plaintiff signed a waiver of that right over to defendant. Defendant and plaintiff got into business negotiations, had lawyers involved, and then this waiver was signed that the plaintiff would allow the defendant to buy the land. The plaintiff had second thoughts after this was signed and thought they were tricked, and so based the whole lawsuit on being tricked into signing this document. And during the course of the litigation, the trial court allowed the plaintiff to amend for punitive damages. The fourth DCA reversed that allowance of punitive damages for two reasons. One's a quick procedural one, is because the plaintiff did not attach the proposed amended complaint to the motion for leave. As you know, punitive damages, it's just an interlineation. Sometimes it's just at the wherefore clause, damages, and then if you get allowed to have punitive damages, you put and punitive damages. Your amendment to the prior complaint could be just a couple words, but this court said you have to still refile the entire complaint. Quote, the rule requires the movement to attach the proposed amended pleading to the motion. The motion to amend and supporting evidence or proffer must be served on all parties at least 20 days before the hearing. The record shows that La Placita violated these rules by not attaching the proposed amended pleading to the motion to amend and by filing the initial proffer only 2 days before the hearing. So the technical procedure, they messed up. And actually this Wednesday, the third DCA had the same ruling in the case I have down here. Again, if you have a copy of this, there are hyperlinks to these cases, but the third DCA said the same thing about someone who moved to amend for punitive damages and didn't attach the complaint. But the more interesting part about this Yatak case is what they said about substantive rights to punitive damages. The court went on to say, even if you messed up the procedure, substantively, you weren't entitled to punitive damages because, quote, punitive damages are not recoverable in breach of contract actions. The counts for promissory estoppel and unjust enrichment are contract or quasi-contract claims. That's a good quote. Can't get punitive damages for unjust enrichment, promissory estoppel. I guess the footnote to this is that in bad faith insurance contract actions, you can get punitive damages. But anyway, generally speaking, no punitive damages in contract type claims. And then on the fraud and the inducement and intentional misrepresentation claims, this is great for if you practice business law. The court was not convinced that an arm's length commercial transaction warranted punitive damages. Quote, this was an arm's length commercial transaction. Yatak and Uribari were both seasoned businessmen. Even intentional non-disclosure of material facts in a commercial real estate sense doesn't justify punitive damages. So, hey, businessmen, buckle up. You guys can lie to each other. Don't come here asking for punitive damages. That's my read on it. Okay, next case, Bioze versus Orison, Broward County Judge Levinson. There was a case involving a fraud and civil conspiracy claim. There was a verified complaint, meaning the complaint was sworn to. Somebody went under oath, penalty of perjury, and said that the transactions at issue giving rise to the claims happened in Broward County, and that the defendant conducts and solicits business in Broward County. The defendant said, no, I'm moving to dismiss based on personal jurisdiction because actually none of what you said is true about my connections to Broward County. And the defendant went under oath and put an affidavit together saying, that's wrong because of this, that's wrong because of that, not Broward County, not Broward County, not Broward County. The trial court had competing affidavits, had a competing verified complaint, meaning someone went under oath to say that there was a connection to Broward County. And then the person who supposedly had a connection to Broward County went under oath saying, I have no connection to Broward County. The court didn't have an evidentiary hearing on it and just denied the motion. The fourth DCA reversed. And the fourth DCA said that because the operative verified complaint cannot be reconciled with defendant's affidavit, an evidentiary hearing is necessary to resolve the disputed facts relating to personal jurisdiction, and the circuit court erred in summarily denying dismissal. Accordingly, we reverse to conduct a limited evidentiary hearing. Another interesting part about this, and it goes back to missing a case management order, so they file a motion, they have to get it set on a hearing, and then all these other things happen in the case. You have to go to a case management conference if one is called, or you have to file certain things. And there was this question of whether during the pendency of the motion to dismiss for lack of jurisdiction, jurisdiction was waived because the defendant did all these things in the case, including propounding discovery, filing a witness list and a mandatory arbitration case summary, and appearing at a case management conference. And the fourth DCA said, no, you don't waive your right to jurisdiction by participating in the litigation unless you seek affirmative relief, and doing those things that I just mentioned is not affirmative relief. Because as we just saw, if this person didn't attend a case management conference, they could get defaulted. All right, here are some contract cases. Walsh Group versus Zion Jacksonville out of Duval County. It's about incorporating contracts into allegations of a complaint. SBP Homes versus 84 Lumber out of Indian River, Judge Kroom. This is about contracts not attached to a complaint but used in a motion to dismiss. Nation Security versus Everest National Insurance, Miami-Dade County, Judge Diaz. It's about summary judgment involving contracts not attached to the complaint nor the motion. Loan Flight Lending versus Bankrate, Hillsborough County. This is about form selection clauses in click-through agreements. Mauder versus Smith, Monroe County. This is about oral agreements to transfer real property outside the statute of frauds. Okay, Walsh Group versus Zion Jacksonville, Duval County, Judge Anderson. This was a lawsuit regarding a road improvement project, and there were claims for littering, trespass, fraud, gross negligence, breach of contract, unjust enrichment. And in writing the complaint, the party attached the contract and incorporated the contract into all of its allegations. Sometimes you've seen complaints or you've drafted them yourselves where it's a 50-page complaint, and when you get to page 40, count whatever it is, you say, and yeah, I incorporate all the allegations from 1 to 39 herein. Something like that was done, and in doing that, the person incorporated the contract into every single count. The contract contains an arbitration clause, and the trial court said, yeah, I'll grant the motion to compel arbitration, but only on a couple claims, because the party didn't intend to arbitrate all the claims, and it just kind of the contract language got in there, but that's not really what the party meant. Well, the fifth DCA reversed that and said the trial court should have compelled arbitration on all claims. Quote, Zion attached the contract as an exhibit to the complaint and incorporated the contract into all of its claims. Having anchored its complaint to the contract and repeatedly trafficked in its provisions, Zion cannot now divorce its claims from the language of the agreement. So it's a cautionary tale of being very careful if you have provisions in a contract you don't want to apply to counts, because if it's at all mentioned, the contract, or you get lazy, for lack of a better term, and I'm not saying the lawyers here were lazy. I'm just saying if convenience, you just reincorporate without parsing it out, you may be stuck with the entire contract and all your claims, and that can be bad if you have an arbitration provision you don't want to have enforced. Okay, the next case, SPB Homes versus 84 Lumber Company, Indian River, Judge Kroom. This was a breach of contract and negligence case regarding installation of windows. This is a very interesting case. So there was a motion to dismiss, and the motion to dismiss attached an agreement that was not attached to the complaint, and the court granted the motion to dismiss. The reason why that's interesting is because there's basic rule of procedure that if you have a contract that you're suing about, you have to attach the contract to your complaint. This is Florida state procedure. Or a picture, literally a picture or a photo of the contract has to be inside the complaint. You cannot file on a contract without the contract being attached to the complaint. The other side of that coin is if you're moving to dismiss and you challenge what you think are inaccuracies in the complaint, that's not going to be dealt with at the motion to dismiss. That's for trial. That's for summary judgment. A motion to dismiss cannot go outside what's called the four corners of the complaint. So generally speaking, you're not allowed to introduce, well, I have this email here that shows a paragraph 2 is wrong. Can't do any of that at the motion to dismiss. That's later on in the case. Well, here, the complaint didn't attach a contract, and the motion to dismiss attached the contract. Two counterintuitive things. Anyway, the fourth DCA said that was fine. The trial court was correct to rely on the agreement that was not attached to the complaint. Quote, where the terms of a legal document are impliedly incorporated by reference into the complaint, the trial court may consider the contents of the document in ruling on a motion to dismiss. Because SPB's complaint referred to the credit agreement as part of the contract between the parties, the trial court did not err in considering the agreement. Very interesting. Another contract case, Nation Security versus Everest National Insurance, Miami-Dade County, Judge Diaz. The trial court granted summary judgment for the insurance company for claims of unpaid invoices. And the ruling involved a contract that was not attached to the complaint, and that was not used in support of summary judgment. Now, based on this last case, thinking, well, maybe we can use the contract even though it's not part of it. Well, this judge, or excuse me, the third DCA differed from the fourth DCA on this and said that that was not proper for the trial court to consider the contract that was not attached to the complaint and that was not used as evidence in support of summary judgment. The insurance company said, well, we don't need to attach the insurance policies. It's unnecessary because we produced the policies during discovery. The third DCA said, no. With respect to count 3, breach of contract, Everest's failure to attach or otherwise make a part of the record in support of summary judgment, the insurance policies which represented the underlying contract alleged to have been breached by Nation Security requires reversal. I don't know why they wouldn't have attached the insurance policies to this motion for summary judgment, but I guess the takeaway is attach all your documents to your motions for summary judgment. A little bit of inconsistency between this case and the last case. Okay, next case, Loan Flight Lending versus Bankrate, Hillsborough County, Judge Farfante. This is a business dispute over leads for a home lender, and Bankrate moved to dismiss based on a New York form selection clause in a contract. So the form selection clause, sometimes contracts have places where you have to sue if there's a dispute, and this one said New York. So Bankrate said, we're moving to dismiss this case from Florida, and if you want to have this lawsuit, you got to go up to New York. And the proof of the forum selection clause being agreed to by the other side was a click-through agreement. It was the actual screenshot. In this opinion, there's a copy of the screenshot. And the click-through agreement, as you know, terms and conditions. Click here, and you've read everything there, and you agree to all these terms and whatnot. It was one of those kind of agreements, but the screenshot just said a quote legal agreement was accepted and didn't delineate exactly what was in the legal agreement. And it didn't say that the other side had agreed to the forum selection clause. The trial court did not allow for an evidentiary hearing on the motion. And the trial court said there wasn't any authority that compels it to conduct an evidentiary hearing on a motion to dismiss where the forum selection clause is specific and detailed and has no discretionary or permissive language. So the trial court looked at the click-through and said, oh, you agreed to a legal agreement, looked at the agreement and said, this is clear, New York. Even though the other side had an issue with whether they agreed, trial court said, no, I'm not doing an evidentiary hearing. This language is clear. You got to go to New York. Goodbye. Motion to dismiss granted. The second DCA reversed and said an evidentiary hearing was required. The forum selection clause was contained in an undated, unsigned master advertising services agreement. So the agreement that was going to be enforced was undated and unsigned. And this is why the second DCA reversed. It said Bankrate submitted an unsigned and undated master advertising services agreement. Bankrate's argument requires cobbling together piecemeal documents to create an enforceable forum selection clause without the benefit of an evidentiary hearing and in the face of Loan Flight's consistent and repeated claims that it did not enter the agreement. We are hesitant to undertake that task. So sometimes the click-through agreements will not work if they're not specific. All right, next case, Mauder versus Smith, Monroe County Judge Jones. This was an oral agreement to transfer real property. It was a lawsuit for promissory estoppel. This usually sends off red flags to lawyers remembering the studying for the bar, statute of frauds. You can't, generally speaking, enforceably convey property through an oral promise. Otherwise, everyone would go around saying, that's my house, he told me that's my house, and the system would be overloaded with frivolous type of claims. And this is the third DCA explained a little bit of the policy of the statute of frauds. It says the statute of frauds grew out of a purpose to intercept the frequency and success of actions based on nothing more than loose verbal statements or mere innuendos. So oral promises to convey property, that's not really a thing. However, here it was a thing because the third DCA said that the statute of frauds was not applicable in this oral agreement to transfer real property. The doctrine of part performance removes a contract from the statute of frauds. In cases involving oral agreements to convey real property, delivery of possession is required in order to prove part performance. And these are the factors that led the third DCA to find that this was outside of the statute of frauds. Mauder orally agreed to convey the property to Smith upon satisfaction of the mortgage. Mauder provided Smith with the payoff information and Smith rendered payment. Critically, Smith continuously remained in possession of the property. He also paid taxes when due, made improvements to the property, and tendered additional consideration in the form of investment in the Blue Marine Hotel. These factors are sufficient to sustain the findings that part performance removed the oral agreement from the statute of frauds and specific performance was warranted. Interesting exception to the statute of frauds. Okay, here are some summary judgment cases. You have Citizens versus Zamanillo out of Miami-Dade County, Judge Acharte. This is about rebutting summary judgment based on a lack of believability. Pickford versus Taylor County School District. Taylor County, Judge Jackson, this is about seeking summary judgment based on a lack of believability. McKee versus Crestline Hotels, Palm Beach, Judge Goodman. This is about an employer not being liable for a vehicle fatality by the banquet manager while the banquet manager was on the phone with the employer while the fatality happened. And then Carpio versus Western Beef out of Palm Beach County, Judge Klingensmith. This was about a genuine dispute over a store's constructive knowledge of the wet part of the floor that caused a slip and fall. Okay, Citizens versus Zamanillo, Miami-Dade County, Judge Acharte. There's a breach of contract regarding the condition of a bathroom. And the trial court issued summary judgment for the insured. So the insurance company lost. And the insured had this support for its summary judgment ruling. Quote, the Zamanillos offered testimony that the toilet doesn't flush, the shower leaks, and the bathroom door opens and closes only with significant force. The Zamanillos combined that evidence with their expert's testimony that based on testing and observations, this portion of the premises suffered a contractually covered sudden collapse. That was the proof. They had their testimony, they had an expert, they won. Citizens, the insurance company, appealed and said, we need to win. For the third DCA, please overturn this because the Zamanillos' version of the events and their experts' version of the events, quote, just weren't believable. They're not believable. How can you believe these versions of the events? And the third DCA said, no, you're not going to be able to oppose summary judgment by saying someone's not believable. There's some really great quotes in here, and it's in the yellow part, but I'll read a little more. So the third DCA affirmed summary judgment and said, We've moved beyond a scintilla of doubt, sometimes being sufficient to defeat summary judgment in Florida by adopting the federal summary judgment standard. If there's a genuine dispute based on admissible summary judgment evidence over a material issue of fact, a trial court can't usurp the fact finder's role. But absent contradictory or conflicting statements or evidence, an argument that a witness, quote unquote, simply isn't believable, or a jury possibly could find differently without pointing to disputed facts in the record isn't enough to create an issue of fact. So this quote here, a witness simply isn't believable. That may be a good nugget to use in a summary judgment brief. Okay, the next case, Pickford versus Taylor County School, Taylor County Judge Jackson. It was a employment discrimination case. This seems to be the other side of the coin, and this is the trial court striking an opposition to summary judgment based on believability. The trial court didn't like the plaintiff's affidavit in opposition to the motion for summary judgment. The trial court said that each of the paragraphs identified in the motion consist of conclusory, vague, and speculative allocations, as well as lacking details. Additionally, the trial court found that each of the above listed paragraphs was inadmissible as they are not based on personal knowledge. The trial court additionally found various paragraphs were irrelevant, mere assertions, conclusory, self-serving, misrepresentations, refuted by sworn testimony, moot, or reference statements made by employees that were outside the scope of employment and didn't have authority to bind defendant. I'm striking the affidavit. School board, you win. I don't believe this affidavit. It's out of the record. Gone. The first DCA reversed that and said, and this is pretty harsh, all of the reasons given by the trial court are factually or legally incorrect. All of the reasons. And the first DCA said, the record contains disputed issues of material facts showing that Pickford was qualified for his teaching position at the elementary school and was replaced by a less qualified white male. The district has offered conflicting explanations and justifications for Pickford's termination, only offering alleged performance deficiencies after the commencement of the litigation. Pickford also identified two sufficiently similar comparators. In addition to his replacement, Pickford identified another substitute teacher who was allegedly treated more favorably. To the extent the district disagrees with this assertion, that's a disputed issue of material fact. So I guess the takeaway is believability can't be used to knock down your opposition to summary judgment either. Okay, next case, McKee versus Crestline Hotels and Resorts, Palm Beach County Judge Goodman. This was a hit and run automobile accident. The hotel banquet manager left a hotel event before it was over. I think the event was supposed to be done at 9 and the manager left at like 8:45. And when he was driving away from the hotel, he was on the phone. They had to assume for the purposes of summary judgment that he was on the phone. The banquet manager was on the phone with the hotel. And while he was on the phone driving his car, he hit and killed a pedestrian. So the pedestrian's family sued and wanted the hotel to be liable for the banquet manager being on the phone with the hotel while the tragic accident happened. And the trial court said, no, the hotel's not liable, and the fourth DCA upheld summary judgment in favor of the hotel. The fourth DCA said neither driving nor using a personal cell phone while driving home was an integral part of the work. The banquet manager was hired to perform as a banquet manager. Driving while using a cell phone was an aspect of his operation of his personal motor vehicle on his commute home. The cost of negligence in such circumstances should be imposed on the owner or operator of the vehicle, not the employer. I think two interesting factors are that the event wasn't over yet. So he left before the event and he was on the phone with the employer, but still the employer wasn't liable. Interesting case in premises type liability case issues. Okay, Carpio versus Western Beef. There was a slip and fall in a retail store. The trial court granted summary judgment for the store, finding that the plaintiff could not meet her burden regarding how long the water was on the floor and thus could not establish the store's knowledge of the water. The fourth DCA reversed and said a person injured in a slip and fall at a business must prove that the business establishment had actual or constructive knowledge of the dangerous condition and should have taken action to remedy it. A plaintiff's testimony regarding the condition and age of a foreign substance alone is not sufficient to create an issue of fact to preclude summary judgment. A plaintiff's testimony must be accompanied by a plus, namely some additional fact or facts from which a jury can reasonably conclude that the substance was on the floor. So on the floor long to give the store notice. So the plaintiff's testimony alone is not generally enough to show that the business had knowledge. but you need a plus. So here there was that plus. The record evidence in this case shows the presence of at least one store employee stationed at the location where the fall occurred, which further supports the possibility of the defendant's constructive knowledge of the water on the floor. So it's a interesting slip and fall case from my perspective on summary judgment, what you need beyond the plaintiff's testimony to show liability. All right. Down to some evidence cases here. Let's see, we have Heritage Property versus Killmeyer. It's a 4th DCA case out of Broward County, Judge Robinson. This is about surprise documents and witnesses at trial. Kerber versus State, Broward County, Judge Murphy. It's about the admissibility of unmanned security footage. Bales versus State out of Martin County, Judge Bauer Jr. It's about the admissibility of Snapchat videos. And Tesla versus Montserrat out of out of Broward County, Judge Spicer. This is about the Apex Doctrine and taking Elon Musk's deposition. For those of you who joined after we started, I'm going to just stop this for a second. I'm going to put this PowerPoint into the chat real quick. And if you could in the chat, put your name and email address, I'd appreciate it just so I can track who has attended. And if you weren't here at the beginning, this PowerPoint has, it's a PDF of the PowerPoint, has hyperlinks to the cases so you can read them for yourself. And like I said at the beginning, if you missed it, this is just my take on a bunch of these cases. There are over 250 written opinions issued by between the 1st and 6th DCAs since January 1st. There were over 30 at the 1st DCA, 40 by the 2nd DCA. Out of the 3rd DCA, there were 55. The 4th DCA, 76. The 5th DCA, 40. The 6th DCA had 12 between January and yesterday of this year. There were a lot of them. I went through them all and tried to find some themes that would be entertaining to talk about in a CLE. So this is how I happened upon these cases. And like I said, there's a lot to these cases. And obviously, feel free to read them in whatever way you want to read them. This is just my take, and I organized it in this fashion. So in any event, here we are with some evidence cases. Heritage Property versus Killmeyer, Broward County, Judge Robinson. There was a trial over an insurance claim for home damage caused by a failed bathroom water supply line. The insurer claimed that the insurer never received a proof of loss form or any email transmitting a proof of loss form. So the person who had the insurance policy supposedly put a proof of loss form together and sent an email, and the insurer said, "I never got it." And the trial court allowed the insurer to present the proof of loss form at trial and to present testimony from someone who supposedly sent the proof of loss form to the insurance company at trial, even though the proof of loss form was not on the exhibit list, and even though the person who said they sent the email of the proof of loss form to the insurance company, that person was not on the witness list. It was a surprise exhibit and a surprise witness, surprise testimony. And the 4th DCA didn't like that very much and reversed and ordered a new trial. And this is a great case for unfair prejudice if, going back to some of the first cases we talked about, if you have lawyers who are maybe not as well prepared at case management or trial settings, calendar calls, this is the kind of thing that can happen if exhibit lists are not put together correctly, witness lists are not put together correctly. This is a great case to show the harm that can be caused, because the 4th DCA is requiring a new trial, even though a trial and all that money was spent on a trial the first time. This is what the 4th DCA said in response to, let me back up. The insured said, "Wait a second, it's not really that big of a surprise, okay? Hold on here. My pretrial exhibit list said any and all correspondence between the insureds or their attorneys, insurer, its agents or attorneys. That was on my exhibit list. You're saying this proof of loss form wasn't there, but I have this catch-all at the bottom of my exhibit list that says any and all correspondence between anybody here. So they were on notice because I said any and all correspondence. I'm sure you've either drafted yourself or seen exhibit lists that at the end you kind of get nervous and you're like, oh, maybe I didn't list every document, and you do any and all whatever. The court said, no, this any and all stuff is not sufficient to detail a proof of loss form. You don't get away with submitting a proof of loss form surprise at trial, even though you said any and all. Nice try, doesn't work. The next argument that the insured said is like, no, we don't need to do a new trial because during cross-examination of the insurance company, I took the proof of loss form and put it in the guy's hands and during cross-examination. So they actually had the proof of loss form at trial during the trial. And then when I later admitted into evidence, like they already had it. The fourth DCA said, no, giving someone a document in cross-examination during a trial is not sufficient notice to allow them to prepare for what they need to prepare for to have a trial on the document. So nice try, no. And the other factor was that the email was not produced during discovery. So the proof of loss form and email was not produced during discovery. The significance of that is if the email had been produced during discovery, the person's name who submitted the email would have kind of been in the ether. And it's like, well, maybe they should have known that people on an email could have been witnesses. That didn't even happen here. So surprise exhibit, surprise witness requires a new trial. All right. Next case, Kerber versus State. It's Broward County, Judge Murphy. The defendant was convicted for stealing from a bank, and the defendant said that the unmanned security footage should not have been admitted into evidence. This is a good case, not just in the criminal context, but in any civil context if you're dealing with security footage. And the fourth DCA said that security footage was properly admitted into evidence, and it went under this silent witness theory. The case is great because they tick off the factors and they tick off how the person met the factors. So it's a great case to look at if you're trying to get something like this admitted into evidence. The fourth DCA said photos and videos from unmanned cameras, such as the surveillance photographs at issue here, are tested for admissibility under the quote unquote silent witness theory, which provides that photographic evidence may be admitted upon proof of the reliability of the process which produced the photograph or videotape. In order to authenticate the photographs, the state presented testimony of the branch manager at the financial institution where the check was deposited. The manager testified that he assists in the process of maintaining the security cameras from which the photographs were generated, and described that the process that the staff performs for testing the accuracy of timestamps. While the manager did not personally pull the surveillance footage, he testified that the footage is made in the normal course of business and that the employees who normally pull the footage do so in this case, or did so in this case. Finally, the manager testified that the footage accurately represented the financial institution's branch location on the date and timestamps indicated. And as for the timestamps accuracy, the staff regularly test the cameras to make sure the timestamps are accurate. Sounds like if you're going to admit security footage, do everything they did here, because they got all the factors right, and the state did a good job in getting this in. Okay, the next case, Bales versus State. It's out of Martin County. Judge Bauer Jr. and the defendant was convicted for home invasion robbery and grand theft of a firearm. So somebody went into someone's home and did a robbery and took a firearm. And the defendant was detained based on a Snapchat video. And at trial, the detective stated this at trial about the Snapchat video. The Snapchat video was, quote, about some of the co-defendant's dirt being all of his dirt. In layman's terms, if the co-defendant did something then, defendant was involved in that. And there was also an Instagram post about the co-defendant posing with an AR-15 rifle. The defendant was convicted and moved for a mistrial on the grounds that the detective interpreted a Snapchat video, but we don't have the video. The detective doesn't have the actual video anymore. His phone broke, and the video that was on his phone is not available, so this is the best we got. And the fourth DCA affirmed and said the defense counsel failed to make a best evidence rule objection at trial, and the objection was only based on opinion testimony. I think this is a cautionary tale, and this goes back to even the first cases we're talking about, attending case management hearings, getting ready for trial, doing all the stuff you need to have ready. If you know that some sort of video is going to come in or someone's going to talk about a video, you should find out whether the video exists. And if it doesn't, you should do a motion in limine so this stuff isn't already at trial and then you're asking for a mistrial after the cat's out of the bag. So to me, it seems like a different course that might have had success would be to anticipate this Snapchat video issue and try to do something about it before the trial. But on the flip side, it is interesting that someone talking about what was inside of a Snapchat video was admissible at trial. There may be a lot of factors that distinguish this from other cases, but it's a Snapchat video admissibility case. Okay, down close to 1 o'clock, and this is our last case. This is Tesla versus Montserrat. This is out of Broward County, Judge Spicer. This was a negligence action arising out of a vehicle crash. An 18-year-old was driving 116 miles an hour and crashed and killed himself and a passenger. And the families allege that the Tesla service technician, this is like the basis of their claim, with the service technician deactivated the 85-mile-an-hour top speed limiting software previously enabled after the person who died tragically complained that he could not accelerate over 85 miles an hour. So the technician allowed for this to happen. Tesla's at fault. Well, before the lawsuit was filed, Elon Musk found out about this and like personally called the families, and he extended his condolences. And according to the families, on the phone call, Elon Musk said, "Perhaps we should not have removed the limiter. We will have to review and revise our policies." According to the family, that's what Elon Musk said. Elon Musk denied saying that, but he did admit to having a phone call, and there were actually some emails exchanged. And as a result of that phone call, the families during the litigation wanted to take Elon Musk's deposition. And like I said, Elon Musk said, "That's not what I said on the call," even though I did make the call. And the trial court allowed Elon Musk's deposition to go forward, but Tesla filed a motion to stop the deposition, and the Fourth DCA stopped the deposition. And the Fourth DCA stopped it under the Apex doctrine, which is a new rule of procedure, relatively new rule of procedure, and said, if you want to take a high-level corporate executive, here are some of the things you need to do. It's a great case if you're either looking to get a high-level corporate executive's depo on the stuff you need to prove, or if you're trying to oppose it, the stuff that you should try to mimic what happened here. But in any event, the Fourth DCA said the Apex doctrine applies and said that plaintiff has not shown that the existing discovery is inadequate or that Mr. Musk has unique personal knowledge of discoverable information. The only arguably unique personal knowledge Mr. Musk may have is whether or not he remembers the phone conversation. Mr. Musk, however, has already twice provided sworn testimony attesting that he does not recall making any statements during the phone call regarding the speed limiter. Under these circumstances, requiring Mr. Musk to sit for a deposition would serve no purpose other than to harass and burden Tesla and disrupt Mr. Musk's ability to meet his obligations to consumers, stockholders, Tesla employees, and other activities integral to his position as CEO. So great Apex doctrine case. Okay, that's all the cases. It's been an hour. This was a free 1 credit hour Florida bar approved CLE. The reference number you need is 2400759N. It's an intermediate level CLE. The CLE was recorded on Zoom. It's going to be rebroadcasted on my YouTube channel, Florida DCA Wizard. That's my company, and I do real-time case law updates. And